Welcome to Discrimination on the Job. This webinar and telelearning series is brought to you by Can Do Multiple Sclerosis, the National Multiple Sclerosis Society, and the Multiple Sclerosis Society of Canada. This is the second in a four-part series looking at employment issues and MS. My name is Laura Coyne, and I'm the Programs Manager for Can Do MS. Your moderator this evening is Christina Forrester, the Employment Services Manager for the Greater Delaware Valley Chapter of the National MS Society. Can Do MS transforms lives. We deliver educational programs on exercise, nutrition, and symptom management to inspire and motivate long-lasting change for those with MS and their families to help them thrive. Please visit the Can Do MS website, mscando.org, to learn more about Can Do MS's online and nationwide in-person programs. Can Do MS is excited to partner with the National MS Society to bring you 15 webinars in 2017. At this time, I would like to introduce Christina Forster.
Thank you. Good evening, everyone. The mission of the National MS Society is to help people affected by MS live their best lives as they stop MS in its tracks, restore what has been lost, and end MS forever. We are pleased to have you join us in tonight's program, and you can also explore other society programs, services, resources, and connection opportunities at nationalmssociety.org. The topic for tonight's webinar is discrimination on the job. We all know discrimination exists. In fact, the Equal Employment Opportunity Commission reported that the number of charges of complaints of disability-based job discrimination hit an all-time high in fiscal year 2016. It's important to learn about your rights and what steps you can take, which is the focus for tonight's program. Many people with MS continue to work productively for years after the diagnosis, and these individuals often have questions around issues such as disclosing their MS, discrimination, and wondering what their rights are. Today, you will learn about your legal rights in the workplace and what your options are if you feel you have been discriminated against. Our speakers will describe case scenarios and tips on how to be proactive in the workplace and what to do if things don't go as planned. Our speakers for this evening are Linda Batiste and Charles Goldman. Linda Carter-Batiste, JD, is a principal consultant with the Job Accommodation Network, specializing in the Americans with Disabilities Act and other disability-related legislation. She has been with JAN since 1992 and is a member of JAN's management team. She has a master's degree in rehabilitation counseling and vocational evaluation and a law degree from West Virginia University. She is a member of the American Bar Association, the West Virginia Bar, and the Disability Management Employer Coalition. Charles, or Chuck Goldman, is an attorney at law with experience in both the private and public sectors. He is admitted to practice in the District of Columbia, New York, and the United States District Court for the District of Columbia. He engages in administrative and judicial litigation before forums such as the Equal Employment Opportunity Commission, as well as counsels private individuals, profit and nonprofit organizations, and federal, state, and local governments in a civil practice base in Washington, D.C. Mr. Goldman attended New York University School of Law, Brooklyn Law School, and University of Michigan. He serves as a member of the Legal Advisory Committee at the Greater D.C. Maryland chapter of the National Multiple Sclerosis Society. He has also published several articles on equal rights, including Understanding the Americans with Disabilities Act, and much more. I am now going to turn the floor over to Chuck to begin the program. Thank you.
Thank you, and thank you all for listening to Linda and me. It's a pleasure and an honor for me to share this seminar with Christina and you and Linda and everyone who's out there listening. When we talk about discrimination and your legal rights, the big one, the big law, is the Americans with Disabilities Act. It passed in 1990. The regulations went into effect a little while later, 1992, and basically it said to employers, you can no longer discriminate in the private sector or in the public sector against a person because if they're a qualified individual with a disability. it's illegal to fail to provide reasonable accommodation. In other words, to help tweak the job so that a person with a reasonable accommodation, such as maybe a private office, maybe a little adjustment in scheduling, can do the job, as long as it's not an undue hardship. But the ADA, while it's the centerpiece, is not the only law. Recipients of federal financial assistance since 1973 have been prohibited from discriminating against people with disabilities. There's also the Family Medical Leave, which gives employees the right to guarantee their job when they leave for an extended period of time. And don't forget your state and local laws. They often cover the smaller employers who are not covered by the ADA. People with fewer than 15 employees may be covered under state and local laws. In my home jurisdiction, all employers are covered. In other states, it's also like that. So just because you have a small employer, you still may have the same right to non-discrimination in the workplace under your state or county local law. It's all one big package, and that we all blend together in a quilt to provide effective protections for people with multiple sclerosis. And Linda?
Hi, everyone. I want to start with a quick polling question to get just an idea of what your concerns are. The question is, what is your biggest concern about discrimination on the job? And the choices we've given you are, number one, losing your job and or your insurance, your health insurance. Number two, being treated differently because of your MS. Number three, being denied accommodations that you need. And number four, going through a legal battle with your employer. So if you could just take a couple seconds there and choose the one that is your biggest concern, then we'll go over the results in a second. All right. Boy, losing your job and or your health insurance, 61%. The other three are all tied at 13%. And I have to say, that's not a big surprise to me. As you heard, I work for an organization called the Job Accommodation Network, and we talk to people all across the United States, both employers and employees with disabilities, about accommodations and rights under the ADA. And I do hear this a lot from people with disabilities, especially people with MS. Losing your job, your source of income, and your health insurance is a huge, huge issue for most people. So on the next slide, let's go ahead and jump into the next section. And what we're going to do, we're going to use some real-life examples and some real-life situations based on my work at the Job Accommodation Network. That's what we're going to start off with. What we are planning to do here is illustrate possible discrimination using these examples. And I say possible discrimination because sometimes it's kind of tricky to know whether you're being discriminated against or not. And I'm going to share the examples. Chuck's going to give you some information about the law and how you determine whether you're being discriminated against. And then I'm going to talk about some practical ideas for moving things along, whether it's discrimination or not, what can you do about it. Later on, we're going to talk about how to take legal action if you have to do that, but we want to start first with looking at some ways that maybe you can avoid that if possible. So on the next slide, our first scenario, our first example, involves different treatment after disability disclosure. And here's the example. You have MS and you've had a flare-up. You don't really need accommodations right now, but you haven't told your employer about your MS yet. You decide you're going to go ahead and disclose in case you need accommodations in the future because you don't want to be dealing with disclosure when you're having a flare-up. So you tell your employer, and after your disclosure, you notice that you're not getting the same assignments as your coworkers, and that's affecting your pay. So Chuck, is this potential discrimination?
It sure is. Because your life has changed and in a way that's affected you adversely, the threshold thing that the employee did right that gave them protection was make disclosure. If an employer does not know that you have a disability, and MS may be invisible, and they may not truly know. If they don't know, they can't be said to have discriminated against you. If once you've disclosed, you're getting different work assignments than you as your coworkers. You have the right to the same equal opportunity as your coworkers, as your peers. These are the people we would compare you to and say, look, the able-bodied worker is getting preferential treatment to me, and it's costing me in my pocketbook. This is all the makings of a lawsuit or an EEOC complaint or state and local government complaint. So yes. Linda?
All right, on the next slide. So as you've heard, if your employer took this action because of your disclosure, and the timing makes it sure look like that, then that's discrimination. But what if something else is going on? What if it was just a coincidence and it really wasn't about your disclosure? One of the things you want to try to do is find out, why did this happen? You could just ask your supervisor about it if you want to. A lot of people that I talked to said that they did talk to their supervisor, and the supervisor thought they were being helpful. They thought, oh, well, you told me you had MS, and I thought I knew about MS, and I thought I would help you and cut down your workload. So sometimes it's just ignorance about what you can and can't do. Sometimes it's discrimination. Sometimes it's just a coincidence. So if you can, try to find out why the decision was made. If your supervisor does have concerns about your performance, you might want to go on record, point out your successful performance record, explain why you chose to disclose. Sometimes employers think you disclose, you must have some issues, you must need something. So go on record saying, no, I'm doing my job great, I have no problems now, I don't need an accommodation, here's why I chose to disclose to you. If that doesn't work with your supervisor, then you can appeal to someone higher up. Maybe someone like HR or personnel, if you have those kind of offices. A lot of times they're going to know more about the law, and maybe they can correct this problem in-house without you taking any legal action. All right, on the next slide, this one involves different treatment to access a benefit of employment. And for those of you who don't know that terminology, a benefit of employment is extra things you get just by virtue of being an employee. Things like employee parking, health insurance, attending social events, all those extra things, not really performing your job, but things that you get because you work there. In this situation, let's say your employer has a telework, which is in this situation a work-at-home program, allowing employees to telework up to 3 times a week at their supervisor's discretion. Just to make sure your supervisor may be more inclined to let you work at home, you mention to your supervisor that you want to work at home because of your MS, that it will help your MS. Your supervisor, in response, gives you ADA paperwork to take to your doctor. So, Chuck, is it okay to make this employee fill out that ADA paperwork just to use the telework program?
The employee with MS is getting the same benefit, is to get the same benefit. The answer is no. Generally, no, unless there's another issue that we don't know about from this scenario. Because if all you want is what everybody else is getting, there's no reason for the employer to have your medical information at this point. If you wanted a 4th day or a 5th day, sure, then you're getting, everybody can get 3. You're subject to the same criteria. The discretion of the supervisor has to be applied equally. At face value, no, this doesn't pass the smell test. Something's amiss here.
Okay, on the next slide, like Chuck said, this doesn't sound like an ADA accommodation because everybody has access to 3 days a week. If that's all you want, then you might want to just clarify that you're using the telework program that everybody gets. You're not asking for anything beyond that. Again, you might explain why you disclosed, just that you thought the employer might benefit from knowing that you were going to benefit from this telework program. If your supervisor refuses to stop the paperwork, then again, contact somebody higher up like HR hopefully knows more about the law and say, I just want to use the telework program. I don't want anything beyond that. Now the next one that I have on this slide, I'm sorry, on the same slide, it's a little more tricky. This is kind of a personal decision. If you think you're just using the telework program but your supervisor refuses to budge on this, you've got to make a decision. Do you want to go ahead and fill out that paperwork and make a formal accommodation request and just move everything along, or do you want to try to take some legal action? You'll hear later on what goes into taking legal action. So in some cases, some people just decide, you know what, I know they shouldn't be making me fill this out, but I really want to get this done and I don't want to go through a legal battle, so I'm just going to fill out the paperwork. Again, that's your personal decision. The employer may be not doing things correctly, but if you want to move things along, some people just opt to go ahead and do that. Hopefully these other ideas will work and you won't end up doing that, but if you have to, this is one option. And again, if you're asking for more than the 3 days a week, then you are in an accommodation situation and you do need to go ahead and fill out the paperwork for those extra days beyond what everybody else gets. All right, next slide. All right, this is an example of negative treatment after an accommodation request. As a social worker, you have a large caseload that requires a lot of driving, and that's making your fatigue worse. So you ask your supervisor to be reassigned to another caseload with less driving. In response to your request, your employer puts you on leave, citing safety concerns because you transport children sometimes. So Chuck, what about this one? Is this okay for the employer to do?
I don't like this either. I think you should have been reassigned to the caseload. I think the request is reasonable. Exchanging of duties is a standard form of accommodation. There's no evidence that you put anybody at risk. You're getting tired. There's no history of accidents. I don't like what the employer did. And asking for change of duties, that with a different caseload, you're not asking for less. You're asking for a different way, a different amount of doing the same, a different load to perform the same net amount of work. So what you asked for was reasonable. What the employer did was unreasonable.
Okay, on the next slide. So assuming that you think you can safely do your job while you're waiting for that reassignment, and that what Chuck was talking about is a situation where you don't really think there is a safety concern and you don't think you should be put on leave. You'll hear me and probably Chuck saying this over and over, put something in writing. A written statement goes a long way. If you just had verbal conversations with your supervisor, then you might as well not have had them. There's no record of them. So make a written statement about your ability to safely perform your job. You can indicate that you didn't say you had any safety concerns. You just said you got tired. It affects your ability to function later on, but you're safely doing your job. But this would help you perform your job and not be so fatigued all the time. You might even want to consider attaching a note from your doctor. You may not need to at this point, but that it might want to lend some credibility to what you're saying. It's not just you saying it. Your doctor's weighing in on it. The last bullet on this same slide here is one that we talk to people about all the time. You're sitting at home on leave. Maybe instead of arguing with the employer about your ability to safely do the job, suggest that, hey, why don't you let me come back to work? I'll do everything else while you sort this out. If you really think there's a problem, I don't think there is, but if you think there is, let me at least do everything else, and then we can sort this out. That gets you back in the work environment. It gets you back to work almost the whole day. Maybe you have to take a little bit of leave for the time you would have been transporting children, but it's a lot better than being out of work, sitting at home, wondering what's going on in the workplace. So that's a practical idea that we suggest to a lot of people, and a lot of people have reported that that got them back to work, and then they sorted it out with the employer while they were at work. All right, next slide. This is an example of a situation where an employee's accommodation request was denied. So here you are a customer service representative working in a cubicle. You have MS and you're having trouble concentrating due to all the distractions in your work area. So you ask to move to a private office. You know there's one open and you want that private office. Your supervisor says no, because if you get a private office, everybody else is going to want one too. So Chuck, what do you think about this?
Oh, this is what we used to hear all the time, and it was wrong all the time, because not everybody has MS, not everybody has a disability. Your request is a reasonable request. There's actually a vacant office. They don't have to do anything, and it's a very reasonable. The management is wrong. They're afraid of something that they don't need to be afraid of, because not everybody is the same in the workplace. Some people have MS, and if handled well, it's explained to coworkers that someone has a need for this, and that's the end of it, without making full disclosure of the employee's medical history. You can just say they have a need for it. You're entitled to this. This is a standard form of accommodation. I would add to what I've agreed with everything Linda said so far about trying to talk your way through it with management and making a record. The only thing I would add that probably should have said sooner is that if you're going to be making a request for reasonable accommodation, even though EEOC is crystal clear, you don't have to use the word reasonable accommodation, you're well advised to use it if you're making it, because sometimes employers will say, we didn't know it was a request for reasonable accommodation. So if you're going to make a request for accommodation, you put in the subject of your memo, request for reasonable accommodation, as a practical matter. You avoid an issue in litigation down the road. And the employer can't say, I never knew. But this is a classic request for reasonable accommodation.
I agree with that 100%, because we get calls like that all the time where the employer doesn't understand whether an accommodation request has been made, so just spell it out. It doesn't hurt to at least spell it out.
Linda, can I add? Okay, I was just going to add very quickly that before the amendments to the ADA in 2008, employers would always say, well, person with MS, are they really a qualified individual with a disability? The answer is crystal clear, yes. So now they can't deny that you're qualified under the law if you have MS. So now they say, I didn't know he was or she was asking for accommodation. So to avoid that, you say request for reasonable accommodation.
The next frontier.
Sorry, yes, next barrier to be knocked down.
That's right. So on this slide, we're back into the cubicle situation where you've asked for a private office. And I'm like a broken record, I'm going to say, if you didn't make a written request, go ahead and do that. Send it to HR. A lot of times a supervisor will be frustrated. Somebody's asking for something. I don't want to give it to them. Everybody's going to want one, and they'll just shut the process down. You want to get the process started back up. So sometimes just making it more formal, getting HR involved, that'll be enough to get it moving again. But one thing to keep in mind, under the ADA, employers get to choose among effective options. If there's another way that you can be accommodated besides that private office, then you want to be flexible to considering those other options, and you might even want to start the conversation about other options. If you're not sure what else might work, you can call us at Jan, or you can call other resources if needed. I just want to give you a quick example of some of the suggestions we make related to this problem, because we hear this all the time. Some employers are even moving to open-air offices. They don't even have cubicles, and it creates a lot of problems for a lot of people with disabilities. But some of the things you could do in a cubicle environment, you can put floor-to-ceiling cubicle walls. Shuts out a lot of noise. If noise is your problem, sometimes that'll solve that problem. Also related to noise, there are noise-canceling headsets. There's sound muffling products you can put on your cubicle walls. We recently saw a new product called Quiet On earplugs. They supposedly make almost silence for you by putting these small earplugs in. And a lot of people like these because they don't want to wear headsets so that they stand out and everyone knows that something's going on with them. So these Quiet On earplugs you just stick in your ear and you can't see them, and they cancel out supposedly all noise. I haven't tried them out, but they're new to the market. So that's the kind of thing that we can help you with. If you're having problems with visual distractions, then maybe you can just move to a corner and face the wall. That's been enough for some people, but sometimes people don't think about those other options. So if you're stuck in a situation where your employer shut down your first request and you want to suggest other options, That's sometimes a really good way to get things moving again. All right, on the next slide. This is where you had an accommodation, but your employer changed it on you. And this is one we hear about all the time. Years ago, your supervisor decided to remove an essential function as an accommodation. And just going back to something we haven't said yet, under the ADA, it's not a reasonable accommodation to remove an essential job function. That means an employer doesn't have to do it. Employers are allowed to do it, but they don't have to do it. In this situation, this person was a longtime employee, knew the supervisor really well, they were friends. This supervisor decided, hey, I'm just going to remove this essential function. I'm not going to make it a formal process. I'm just going to do it. That supervisor retires. Now a new supervisor comes in and says, hey, you're not doing your whole job. You got to be able to do your job or you're going to be terminated. You say, hey, my old supervisor knew I had MS and did this, so why don't you keep doing it? New supervisor says, I'm the supervisor now and I'm not doing it. Do your job or you're out of here. So Chuck, can this employer do this?
Well, a qualified individual is a person who, with or without reasonable accommodation, can perform all the essential functions of the job. Now, what the employer had done previously was eliminate one, which really is not, it was going beyond what was required. So saying, I really would like you to do the essential functions of the job is not bad, but that doesn't mean you're out of luck. You can say, I need accommodations to do this essential function. And then you go in to have a full dialogue on the accommodation, on how you perform all the essential functions. So they're not 100%. Totally off it. Go ahead, Linda.
I was going to say I agree 100%. That's, you want to start the accommodation process, and that's, a lot of employees think that the new supervisor can't make these changes, but it's really important that you know that, hey, they probably can, but that doesn't mean you just start in and do your job or you're going to be terminated. That means that you look at accommodations. Did you have something else to check on that one?
Yeah, you said something very important just a second ago. You don't necessarily get the accommodation you seek. You get what's effective. And it's supposed to be a dialogue between you and the employer. And you bring in people like Linda, like your local chapter, but particularly people like Linda and experts like that, who can help the employer. Because their expert is in what the company's doing. Their expertise is not in accommodations. Maybe HR knows, which is why it's very good to talk to them. But Linda's absolutely right. You don't get necessarily the ideal thing for management. And when I've represented management, I've always said, give the employee what they want, because if they screw it up, you can't blame anybody. But you get what's effective to help you do the job. And a dialogue is what we're looking for. And bringing people like Linda into the dialogue is good.
Exactly. And on the next slide, that's one of my main points there is go ahead and make your written accommodation request. You want to buy some time here. You don't want the supervisor booting you out the first day you can't do your job, because if you could have performed that essential function without accommodation, you would have been doing it. So go ahead and stop the clock, make an accommodation request, copy HR, summarize the situation for HR. Say you didn't know you were going to have to do this because you have not been required to do it for X number of years or however long it's been. If you're pretty sure that you're not even going to be able to do that essential function with accommodations, or you just want to not try to do that because of the stress it's going to place on your medical condition, you can ask for a reassignment as well. So if you're aware of a vacant position that you might be qualified to do that you'd rather have, you can skip to that step and go ahead and ask for a reassignment. If you don't ask for a reassignment, the employer is supposed to try to accommodate you in your current job. So if you know that's what you want, go ahead and ask and get the ball rolling to start looking at some vacancies. But this one is a really tricky situation, I think, because you want to avoid that power struggle with that new supervisor. You want to nip that as soon as possible and get HR involved before it gets ugly. All right, next slide. Laid off or downsized, and this is one I hear about a lot too. You're out on leave because of an MS flare-up. You've been released to return to work, and you're getting ready to come back after being off for a while. Before you went out, you were assured that your job would be held. But after you were released to return to work and you let your employer know you're coming back, your employer says, oh, sorry, your job has been eliminated due to downsizing. Chuck, what do you think about this one?
Well, the biggest question, this doesn't pass the smell test at surface. You'd want to know a lot more. If the employer had eliminated a slew of other jobs, I once had a company that laid off 25% of its workforce and eliminated whole departments. So you want to know more here about who else is being cut. At face value, this does not seem right, but you have to put this, you're being terminated, the individual is being terminated in the context of whether layoffs. If this is an individual layoff, this isn't going to fly.
And I agree. On the next slide, one of the things that I think this situation is hard because you're out of the workplace. You're not there where you know exactly what's going on. If you can stay in contact when you're on leave with somebody in the workplace, if you have friends there, maybe you can find out if you were the only one downsized. Try to find out if your position was filled. We've had people call and say they saw their job advertised in the paper, and that's how they found out about it. So you want to try to find out what happened if you can. It's one of those situations where if you can't find out, then you need to call somebody like Chuck and maybe file a complaint if that's where you want to go with it. But getting information can help you decide whether that's the right thing to do or not.
Well, the better employers, the more sophisticated employers, when they run a downsizing, will give you a list. They'll announce it company-wide, and they'll say, here are the departments. These are the jobs we eliminated. These are the people, male, female, over 40, under 40, disability, non-disability. You get a wealth of information, and chances are when they have something like that, it's going to be clean, and you're not going to be able to touch it. But you do need information. Linda's spot on right.
All right, on the next slide, we want to just review our general tips for dealing with potential discrimination. I'm going to start, and then Chuck, you can chime in. I've said on every situation here, you want to put something in writing so that you have documentation of what you said to the employer and what you tried to do to resolve the situation internally. Involve higher-ups. If you've just been dealing with your supervisor, again, they tend to know more about complying with the law. Try to offer solutions. I mentioned on that one situation that if you want to try to come up with some other ideas, if the employer just shut your first idea down, go ahead and throw out some ideas. The employer should be in there doing all of this too. The employer should be making a good faith effort, but sometimes they don't. Sometimes they don't know what they're supposed to do, and it's kind of up to you to get the ball rolling. So offering ideas to get things where you need them to be so you can keep your job is something that you can try to do. Do you have anything else, Chuck, on that one?
I would add that first of all, I agree with you 100%. And some solutions might come from a previous job. If you had things that, if you've gone from one company that does similar things to another, and you had accommodations on the previous job that were effective, this employer may not know, may not be as the new employer may not be as knowledgeable, and say, well, look, when I was at the other company, this is what worked, and they may say, well, we're not the other company. You say, yeah, but I'm still me, and this is similar, and I think we can try it. Sometimes you can say, let's try an accommodation for 90 days or 180 days and revisit it periodically.
I love that idea. That talking to employers about accommodations, sometimes they get scared. This is doing something differently. This, like you said, this is not the way our company does it. If you toss it out there as, hey, let's try it, just a month or whatever, employers sometimes will jump on that because it's like, oh, we're not locked into it. Even though they're not locked into it anyway, if it doesn't work, they don't really understand that. But if you say, let's make an agreement to do this temporarily, sometimes employers will do that. That is a great idea. That's one of my favorite suggestions to get things moving. All right, on the next slide, we want to talk briefly about a very, very important subject, and that's harassment and retaliation. And another thing that we didn't include on here called interference under the ADA. These are considered discrimination too, just like we've been talking about, but there are special types of discrimination, and I think in some ways they're worse than other types in some situations. The one example that we're giving here is an example of ADA interference, and this is something specific to the ADA. It's like retaliation, only it's broader. So here you ask for an accommodation, and you turn in supporting medical documentation like the employer requests. In that documentation, your employer sees that your doctor recommended medication that you decided not to take because you didn't like the side effects. Your employer says that if you do not try that medication first, he will not consider your accommodation. Chuck, can you talk about this issue?
This is a tricky one because you've done the right things. Your doctor and the employer has gotten documentation, and you're supposed to be doing what the doctor orders, or else getting new doctor's orders if the side effects are causing you a problem. What you would have to do here is tell the employer that you're in the process of getting new orders from the doctor because the medication is causing a side effect that you're going to get them more medical information. If your doctor recommends things and you don't take your meds, and then you get overly fatigued, you're going to be losing here. If you're in the process, you've got to bring your doctor on board with you. Your doctor's got to be in sync, and you have to be in lockstep with the doc when you're asking for an accommodation, because his or her information is going to go about your MS. It's going to go to the employer. And the doctor wants you to succeed. And the employer is not being unreasonable here. But you can say to the employer, look, I had a side effect. I'm in the process of getting it out. Let's keep the dialogue open.
Yeah, I think that's really important to get your doctor involved, and maybe you should look at what the doctor's turning in. Employers are not allowed to dictate what medication you take. That's between you and your doctor. So you really don't even want the employer to have this information that medication was recommended and you opted not to take it. That's really not part of this equation here that the employer needs to know. Once they know that, of course, this is what they're going to say.
That's exactly
you don't
right.
You don't want them going there. This could be classified as illegal interference under the ADA to say you have to take medication that you and your doctor have decided not to take. But if you turn in something from your doctor saying that the doctor thinks you should be taking this, that just creates this whole bunch of confusion and creates this problem here. So Chuck's absolutely right. Before your doctor turns anything into your employer, review that with your doctor if you can and talk it through. Make sure only the information that is necessary for the employer to have goes over, because otherwise you're going to be in this kind of situation.
Linda's right. Linda's absolutely right that you and your doctor agree on. Here, in this slide here, you and your doctor are disagreeing, and the employer is playing on that, and that creates a problem. Because
and you don't want that.
You don't want that. And once you get your doctor involved, you have to say, Doc, this is real important. Shoot straight with me. This is my livelihood. You know, I know you want what's best for me. We share a common goal. We want what's best for me, and I want you to tell me what's best for me that I can work with in the job market, in my job, and here's my job. And I would give the practical suggestion, I would bring my job description or give a sheet to my doctor what my duties were and say, this is my job, Doc, help. And
so some tips for dealing with potential retaliation or harassment or interference, like the example here, it's very similar to what we talked about with other types of discrimination. You want to document what's going on so that you have a paper trail in case it does go into legal action, and you want to involve the higher up, same thing. With retaliation or harassment, and Chuck, you can certainly have more to say on this, but I think this is one of those things that if it doesn't stop after you report to the higher up, sometimes you may end up taking legal action, and that's what we're going to head into next. Chuck's going to talk about how you take legal action, but first, Chuck, do you have any tips here that you want to add?
Yeah, I would say it's important to note, we talked about the increase in disability cases. The other fastly rising cause of action that's filed at EEOC is retaliation. You engaged in legally protected activity. You had an EEO claim, you sought accommodation, and after that the employer retaliated against you. They did something bad to you in the workplace. All you have to do when you're proving retaliation is prove your engagement in legally protected conduct. You were a witness in an EEO case, you filed a charge, and then 6 months or so or less later, usually, you had something bad happen to you. You're no longer in a retaliation case necessarily proving that you're a qualified individual with a disability. You're just proving that you engaged in the protected activity. And it's a lot easier to prove than anything else. But retaliation is usually what the law says in temporal proximity, which usually means it happened a few months, maybe 6 months, and occasionally up to a year after you engaged in the legally protected action.
And then speaking of legal action, move into your section here on how to take legal action if you have to. Take it away there, Chuck.
Okay. You can file, we talked in the beginning about the ADA. The ADA is administered by EEOC. They have an intake questionnaire. You file a charge there. The events at work, or you can file any one of these events, or something bad happening to you. You're being denied accommodation, you've been fired. Termination claims, the most popular one in the bunch here. Hostile work environment, you're being treated differently, you retaliated. Wrongful disclosure means someone who doesn't need to know about your having MS has been told about your MS. Under the law, particularly the ADA and privacy state and local laws, only people who need to know about your medical condition get to know. Your employer does not have the right to stand up at a staff meeting and say, I'm accommodating Chuck because he has multiple sclerosis. Can't do that. It's my private life. These are the types of things that make you fill out a charge at EEOC or your state and local government agency that works with EEOC. And in our jurisdiction, the District of Columbia Human Rights Office is very good. The state of Maryland office is good. So there are places where you could file. And you would fill out an intake questionnaire. And then they would write up a charge. And then at that point, you may have to hire counsel or seek counsel. But these are all classic events. Something bad has happened. It's going to cost you money in the workplace. It's going to cost you stress and hopefully not cause you an exacerbation, because then you're really hurting. What's next? Okay. Lawyers and how to find one. National has office. I was introduced as being a member of a committee. Our local chapter has one, but if you're a member of an MS support group, that you can ask in the support group. Your friends, your family. The Bar Association will have a bunch of lawyers who do employment discrimination. You may be a member of a group plan, like Law Points, the AARP used to have, but various employers have plans. Or if you've had an attorney previously, you can say, I need a referral. You're a divorce lawyer. You're the guy or woman who closed on your real estate house is not the right person. You want someone who knows something about employment discrimination. But ask around. Bar associations, state and county and city bar, all have referral networks. And if you can't afford them, you have what's called you can say, I need pro bono legal help. I need someone for free or at a discount. That's called low bono. So there are plenty of places. Now, never be afraid to ask a lawyer a question. What's their experience? Is it recent? Is it EEOC? Is it with my employer? Have you worked with persons with neurological conditions? I've worked with people with epilepsy. I know about seizure disorders. I know about MS. I've also worked with other disabilities. But you can get a feel from the lawyer. Don't be afraid. You want the lawyer's interviewing you, but don't be afraid to interview the lawyer as well. It's a two-way street. You're going to be talking to this person, probably for half an hour, 45 minutes. Are you getting comfortable with them? But ask the questions. And I don't know where the money slide is, but money's not a dirty word. You should be able to talk about this. Find out. Before you go in, can I come see you do you offer free what's your fee? What's your hourly rate? With our legal advisory committee, we give out free consultations anywhere from usually 30 minutes free in the DC area. Would you do the work on a contingent fee basis? Means if I recover money, then the lawyer gets paid. Sometimes there are other contingencies. If I get you a new job, the lawyer gets paid. You talk about different events that would trigger the lawyer getting paid. And sometimes lawyers we value time. So you should ask them, what's your rule of thumb if I'm late or I need to reschedule? And most people, if it's a medical emergency, say you have an exacerbation, they're going to say, not a problem. But don't show up late without an excuse. You're going to get charged in most offices. But ask. And if you're going to a big firm, say, who's going to do the work? You go see a partner and he's got 3 associates. Say, who's actually going to do the work? And here the 2 bottom questions are really important. And this I actually got from a neurologist who said the same thing is true for medical things. You say to the lawyer at the end, is there anything else I should have asked you or that I should have told you? Did I miss something? And the lawyer hopefully will tell you yes or no. If you miss something, he'll ask about it or she'll ask about it. And here's the question you have to ask yourself. Do I feel comfortable telling this person that about my most intimate life, that I had a client once who had accidents because her job was too far from the facility. And I give her a world of credit and I felt flattered that she could tell me this. I've had clients who couldn't tell me things. And they said, well, why don't you tell it to the judge? And I'll say, you never told me. And that's embarrassing. But, if you feel your boss is beating down on you and you don't feel like being a loving spouse or supporting spouse, that's important. If you don't feel like eating, you don't feel like working, or you're getting depressed, can you tell your lawyer your personal things? It's who you are. It's part of your case. In the various examples I've shown, it's part of your damages. That's one of the things we can recover. It's part of the money. If an employer is causing you pain and suffering, and you just feel like a stay-at-home, you don't want to you're antisocial and you can't do anything. And the employer doesn't have a right to make you feel that way. But you got to tell the lawyer so he can tell the judge. Are you comfortable telling him that detail? It's an important question. Various things under the law. The law gets you different things. If you've been fired, you might get your job back with back pay. You might get a promotion if you were denied a promotion. And your benefits with leave, sick, annual, whatever. The law gives you a prescribed set of remedies. When you're negotiating, And if you get your job back, it may come with health insurance and things like that. And I should mention the Affordable Care Act, because under the Affordable Care Act, if you've been fired, that's a triggering event, and you can buy health insurance on the exchanges now. But when you have a case, not every case is the same. Some people, if you just need accommodation, we're going to try and get you an effective accommodation, and we're going to get you the money you lost for your pain and suffering. But your pain and suffering may be different from the next person who comes in the door. If you're negotiating a settlement with an employer, you have to say, okay, this is what I need now. I need money, but I also, if I'm going to be leaving this job, I have to think of the long term. I need a reference. What happens 5 years from now when I've left the ABC company and I'm now applying to work at the XYZ company? I want to make sure that the ABC company is going to say good things about me. In other words, you have to think both short-term and long-term when you're negotiating. A judge or jury is going to give you the remedies that the law allows: back pay, front pay, damages that you can prove. Thinking long and short-term comes in when you're negotiating a resolution. And a resolution is a settlement. Your case is over when that happens. But you have to say, yes, it's over, and now I don't have to worry about the ABC company, but I want to know, so when I go down the road, I'm going to be okay. I am going to have health insurance. I am going to have a good reference. This is what management will do for me. Here are examples of the remedies. You're going to get an accommodation or a new job. And you don't want people having bad things in the files about you. You're going to get your leave back. You were out, you had to take sick leave. You took leave without pay. You took annual leave. If you were missed training, you're going to want that training restored so they keep you on the foot with your coworkers. These are just standard remedies. Health insurance and benefits are critical. Damages, everybody says, I want punitive damages. They're real. Punitive damages are the old-fashioned way. Think of flogging in the 15th century. It doesn't really happen all that often. Many years ago, we had a case in district court where someone was literally crawling around the DC public school. And the judge, we won the case but on the merits that it was discrimination, but the judge said no to compensatory damages, to punitive damages. Yes to compensatory, but not even in such a case like that, punitives. Punitives, the guy practically has to stand up and use one of the words you can't say on television against you in the workplace. Compensatory damages are designed to compensate, to give you money, to pay you for the harm you've harmed. And here's the other thing, the beautiful thing that lawyers love and clients love it too, is legal fees. If you're successful, you can get your fees paid. And usually you can get them paid at a higher rate than the lawyer's billing you for, because in our district and in others, there's a matrix that we use to get paid by. But they're reasonable. Not every legal fees, and there are sometimes battles of them, but chances are you should be able to negotiate legal fees, or the judge will award them if the parties can't agree on them. And I think we got time for questions now. Am I good?
Yeah, I just want to briefly mention how to contact us at JAN. We don't give legal advice, but we do provide information on what the EEOC says about the Americans with Disabilities Act. The EEOC is the federal agency that enforces the employment sections of the ADA. So the information they provide can be very, very helpful in trying to figure out what your rights are and what your employer should be doing. So we can share that information with you. And then beyond that, we'll try to give you some practical ideas, like some of the ones I mentioned, to hopefully get things moving so that you don't have to get into the legal options that you just heard from Chuck. But if you have to get into them, then as you heard from Chuck, you've got lots of resources and people that you can tap in to get some help there. And with that,
I'm sorry.
Go ahead.
I was going to say, Linda, you offered them one thing that you didn't say one magic word, that you're free.
We are free. That's right.
That's important.
We are free. That is very important. We'll chat with you about the situation free. You can call us toll-free. As you saw on the last slide, we've got a toll-free number, and you can email us as well. Our website is askjan.org. Get on there, and there's all kinds of ways that you can contact us. Thanks, Chuck. That's right. We forgot to say we were free. And I think we're ready for questions now.
Sure, great. Thank you, Chuck and Linda, so much. We are ready for questions, and just wanted to give a quick reminder to anybody listening, if you do have a question, feel free to type it in the question and chat box that's found in your control panel. The first question that we have is, if you disclose to your principal but not HR, does that count as a legal disclosure in the eyes of the law?
Yes. Your boss knows, absolutely. You don't have it. Does you've got it, you can tell your boss. That's fine. That's disclosure. Linda, you want to add?
I totally agree.
All right.
We're knocking these out.
The next question I have is an individual who has been denied for family medical leave many times. They don't currently need it but want to have it in the event of a major exacerbation. And their most recent denial was based on the fact that they don't use sick leave and have plenty stored up. But nothing medical was cited in the denial. Can anything be done to facilitate that?
You want me to take a crack, Linda, or do you want to do it?
I'll give my slant on it, and then
you
probably know more about it than I do. But my understanding of the FMLA is it can run at the same time as your sick leave. I mean, most people don't want to run it just in case you need it later on. So if you're saying that you weren't approved for FMLA, that you had to use your sick leave, they can run at the same time, and then you're out above. So most of the time what we hear is that the employer wants to designate your leave as FMLA qualifying so that the clock can start ticking on your FMLA. It really, if I'm understanding your question right, it doesn't necessarily benefit you to push to run FMLA because it would just run at the same time as using your sick leave. Chuck, I don't know if
I agree with you. You want to run the FMLA later than the sick if possible, because it guarantees you want to make them consecutive, not concurrent benefits if possible, because that keeps you in the workplace longer, which I think is what we're trying to say here, right, Linda?
That's my understanding of the question. If we got that wrong, then let us know. But yeah, I don't think you necessarily want to push that. Because like Chuck said, you want to save that for if you run out of leave, then you've got 12 weeks of protected unpaid leave in addition to your paid leave.
Protected means you're guaranteed to get your job back after FMLA. That's the meaning of protected.
Great, thank you. Next question we have is my employer allowed to require a doctor's note when I move from using a walker to a cane?
From a walker to a cane? What else changed? Anything else? Why did they get the note for the cane in the first place? Are you falling down, or is there an issue beyond changing the mobility aid? It seems like an unnecessary request, but this is one where, in the spirit of what Linda said, which is basically that you catch more flies with honey than you do with vinegar, you might say to the employer, I'm a little perplexed as to what's going on here. Can you help me out? Is there something I'm not seeing because I'm so close to this? And talk to them and say, generally I would say no, but it's not worth going to war on if your doctor is going to do this. But the question might be, what's coming next in your mind, which would be understandable. But I would sort of talk to the employer and say, excuse me, or talk to HR and educate them, say you're confused. Linda?
100% agree. I wouldn't want to let a medical inquiry like that or a request for medical documentation just hang in the air and do nothing. You want to, if you don't understand why it's being requested, put something in writing saying, you know, I'm not really asking for anything and I'm not really having any performance problems, so I'm not real clear on why you're asking for medical information about my use of the cane, and copy it to HR if HR wasn't the one that asked you. But typically, there's got to be a valid reason to ask you for that, and like Chuck said, without more information, I don't really understand why that would be a valid reason to ask you for medical information unless something else going on.
The accommodation process is a dialogue, and lawyers in legal shorthand in their private conversations will say, you know, it's a dialogue, and the person who stops talking loses. So you don't want to be the person who stops talking if you're the employee. You want to be ready to talk. If the employer stops talking, that's to your benefit legally. But reality is you want to have a healthy dialogue with your boss.
Great, thank you. Question, I've been out of work for 5 years now. Is there anything I can do now if I think that I was discriminated against?
Probably not. Statute of limitations, ADA itself has no statute of limitations, so it follows the state employment discrimination law. It would depend on the state law wherever you're situated. In most states, employment discrimination law is not going to be 5 years. What you might want to do is seek a pro bono consultation with someone in your state and see if there's some other state law that you might be able to latch on to. But you're probably going to be out of luck under the ADA and the state anti-discrimination law. There may be some other ongoing problem there that you may not have realized that might have kept the statute alive. So I would not expect a lot. But I'd ask to see if I could find someone who would talk to me for half an hour for free about this, but have the full chronology as to why you didn't seek help sooner, etc.
Great, thank you. Next question is, they offered me a generous severance, but in order to get it, I had to sign a lengthy agreement stating that I would not pursue legal action under the ADA, etc. I felt very much in a bind and I needed the severance money, but by signing it and agreeing to it, I am saying I would never pursue legal actions. Is this enforceable? And this person did sign it and took the money.
It's not only enforceable, it's binding. Unless for some reason you didn't, generally speaking, it's going to be binding. And generally speaking, a settlement agreement is going to say something like that. Money, things, it's going to say that's the end. You release all claims, and it's going to be game over. We're parting over, lawsuit over, EEOC charge, state law charge. All of your legal rights are gone. In return for, and the employer is not going to admit fault. But I've seen settlements of $300,000, and nobody admitted anything wrong. But a chunk of money is changing hands. So even though they didn't admit they did something wrong, they did something wrong, and they know it. Otherwise, they wouldn't be paying you. Severance agreements are your divorce. They are your legal divorce agreement. They're final, they're binding, and I hope the person had legal advice. The only times you sometimes get extra time to revoke it is if you've had a claim of age discrimination under the Older Workers Benefits Protection Act. There's an additional time after you sign a severance agreement to revoke it, and the agreement should state that. But if the person signed this agreement and more than 21 and either it had no Older Worker Benefits Protection Act claim in it, or the time has elapsed, the agreement is binding. And that's why we strongly urge people to see people, even for just a consultation before you sign it, because this is a binding contract.
And Chuck, if I could just add,
Please.
you've probably seen that EEOC put out a guidance on waivers of your rights and what the employer needs to do to make those binding. And like you said, a lot of times they are because they know what they're doing and they try to do them right. But there is a guideline that EEOC put out on what makes those binding, and I think it's written for individuals who are contemplating signing those. I think it's a really, really good document to review if your employer hands you a severance agreement and asks you to waive your rights. We have a copy of that on our website at askjan.org. If you have any trouble finding it, you can email me or give me a call, and I'll tell you where that is. But it's a really good document just because sometimes you don't have time to go get an attorney or you can't find one, and it does kind of give you at least some guidance on how to help ensure your rights when you're contemplating signing one of those.
That's an excellent point, Linda. The other thing you can do, if you get a severance agreement and you say, I need an extra time period of time to talk to an attorney, because very commonly an agreement will say you've had the opportunity to be advised by legal counsel of your own choosing. So you say to the employer, hey, it says I have had time to get a lawyer. Now give me an extra week, 2 weeks, a month to be advised by a lawyer. And they'll generally give you some extra time. But Linda's point about waivers is very important. It's a good one.
Great information. Thank you, guys. Next question is, what is the best way to track events that you believe are discriminatory, and how to best collect the proof that it took place?
You want me to start, Linda, or you want to do this?
Yeah, why don't you start? I mean, just from a
Okay.
practical standpoint, I just talk about write down everybody that might have witnessed what you said, write down dates, times, who said what, if it was your supervisor or whoever. But you're probably better from a legal standpoint to say what's useful to you as a practicing attorney.
Well, what I tell people, if you think something bad is happening, keep a diary, keep a log of what happened, but keep it on your private computer. Do not put it on your workplace computer. Or write it down, go to CVS, go to Kmart, get a notebook, write it there. It's cathartic for you to talk about it. If it's causing you stress and you need to, see a therapist and talk about it. But keep a private log so that when the case comes to trial in 2019, you can say on March 1st, 2017, my employer said X, Y, and Z in front of me at 9:15 a.m. And I know this because I wrote it down at 7 p.m. that night. I made an immediate note, put it in my pocket, and then I put it in my private computer at night. And you have a record, and that's very powerful information. So we say keep a record, as Linda suggests, but keep it privately because it may well disappear if it's on the employer's internet, or anything on an employer computer could disappear.
Thank you. Next question is, if I asked for certain accommodations and my employer constantly denied or altered the accommodation, is that discrimination?
I can start with that, Chuck. And
yeah, go ahead.
Yeah, I would agree. Maybe what we always talk to people about when you get denied an accommodation, try to find out why it was denied, because there might be a valid reason. If, like we talked about before, there might also be other options that you could explore. Just if the employer just doesn't like that accommodation, then maybe you can bring up some other ideas. But you really need to know why it was denied before you can know if it's discrimination or not.
The law says you get what we call an effective accommodation. It may not be exactly what you asked for. You may say, I'd like to, for example, you might have said, I want to work at home 3 days a week, Monday, Tuesday, and Thursday. And the employer may say, look, for this business reason, Thursday you absolutely have to be in the office for whatever reason. So we're going to give you Monday, Tuesday, and Friday. And that enables you to recharge your batteries, or as long as what the employer does is effective. If you wanted a cubicle or with certain earbuds with high walls, and the employer goes higher, or gives you a private office, okay, as long as it's effective. That's the question. Is the accommodation, is what the employer does effective? Does it help you perform the essential functions of your job?
Thank you. Do these laws also apply to part-time workers?
That's a good question. That's a debate that's been going on for a while. So sometimes the answer is sometimes. It's tough. Linda, do you want to comment?
I know the EEOC says that part-time workers are covered at least by the ADA. Like Chuck said, that you get into different jurisdictions and different courts, they may have something else to say about it. But at least the EEOC says yes, it applies to temporary employees, part-time employees, full-time employees. It does not apply to independent contractors who are truly independent contractors who don't really meet the definition of employee. But yeah, according to EEOC, for what that's worth, it does cover, ADA does cover part-time employees.
Right. Sometimes the courts don't agree with the EEOC, but it's nice to have them backing you to start with. That's why I hesitated, because sometimes the courts don't always agree with the EEOC on that.
Which is very frustrating and hard for. I think that makes it really hard for people to understand their rights, because you read the stuff from EEOC and then someone says, well, no, that's not the law in our area, and it's just very confusing. So I think that's why, if you can work these things out with your employer, if you can try to negotiate and get what you need, you may be miles ahead of getting into the court systems where who knows what's going to happen. When you have to, it's a great tool to have, but if you can keep that from happening, sometimes that may be your best bet.
Well, I think Linda's right, and we've talked about different laws and going places. Remember, if you and your employer can sit down and resolve the problem, you have control over the solution. To the extent you choose to agree and have a dialogue with an entity with which you have a relationship, or with which you're terminating a relationship. If you go to a court, some crazy third party called a judge could be the one that says yes or no. You don't have control. A settlement or dialogue, working out the accommodation, you have input. It's your life. It's your job. You have control. And that's why very commonly at EEOC, at DC Human Rights, they offer mediation where the parties have control over the outcome. I will be accommodated X, Y, and Z this way. I will work Monday, Tuesday, Thursday from home, or I will have this accommodation, this office at that day. It's your ability, as Linda is describing, catching more flies, and I said catching more flies with honey than with vinegar.
Great. Thank you guys so much. I think that we are all out of time for questions right now, and I believe Laura wanted to share additional information about CanDo MS.
Terrific. First of all, I want to thank Linda and Chuck for their informative presentation, and Christina, thank you for moderating. I would like to inform you of some additional resources that you might find helpful. On the CanDo MS website, mscando.org, you will find our archive webinars, e-news, and library articles. We also have an Ask the CanDo Team platform, which allows you to submit a question to our experts. And Christina, back to you.
Great, thank you, Laura. So I just wanted to highlight some of the National MS Society's resources that deal with employment. We have a variety of employment brochures, including a win-win approach to reasonable accommodations. Employment Matters is also a video segment about key employment issues that has a toolkit for job searching. And the website listed here, nationalmssociety.org/employment, is full of employment information, including disclosure, accommodations, and resources on various other employment topics. If you did not get your question answered this evening, feel free to email your employment-related question to employmentquestions@nmss.org, and we will follow up with you. Thanks so much, everybody, for joining us tonight.
Terrific. And the next presentation in our webinar and telelearning series will be on Tuesday, March 14th at the same time, 8 p.m. Eastern Time. And the topic will be weight management and nutrition. As always, you can register for this on the Can Do MS website, mscando.org. And for those of you participating tonight, I would ask you to complete the survey that will appear on your screen after the webinar is over, and your feedback does help us to continue to improve our webinar and telelearning series. You will also receive a PDF copy of tonight's slides by email. One last thing before we end tonight. If you do enjoy our webinars and would like to help support them with a donation, you can text 970-626-6232. I'd like to wish everyone a great night, and thank you very much for participating in this webinar.